Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the NPTEL online certification course titled Medical Law. As last lecture, lecture 1, we have discussed the interface between medical profession and law. Today we are starting with the lecture 2. Myself, Dr. Chaitanya Mittal, medical legal consultant at Dr. B.C. Roy, Multi-Speciality Medical Research Center, IIT Khanpur. Today we will start with lecture 2 of module 1, role of medical practitioner in justice administration. So, the concepts covered in this lecture will be medical practitioners as witnesses, determining the cause of death and various other parameters by the doctors, determination of age by doctors, various tests on sexual assault victims, various scientific tests conducted by the doctors. The important keywords of this lecture is medical witness, forensic medicine, two-finger test, polygraph test, narco-analysis test, brain mapping test. So, coming to the introduction of this lecture, the role of medical practitioner in justice administration. If doctors are aware of the precise requirements that courts have of them, they will be in a better position to assist court in making wise decision or making a good decisions or the judgments or for the benefit of the community. For example, when requesting a medical report for an inquest, attorneys may request a factual description of the physician's involvement in a specific case. Except insofar as it concerns his personal involvement in the case, the doctor is testifying as a professional witness or expert witness of fact and it is not offering an opinion. What the doctor has seen, heard, read or done should be the main focus of the report. It should not express opinions or conjectures. As an alternative, attorneys could request an expert report. There are tight guidelines or the strict actions that court follow when accepting expert testimony. The role of medical witnesses in the courts of law. In a criminal case, a medical witness is crucial to the court's decision making process and aids in determining the guilt or innocence of the accused. A medical observer is expected to possess expertise in forensic medicine and a fair understanding of all medical specialties and related fields imparted to a medical student pursuing their education. A qualified medical witness must frequently appear in court to take depositions and he or she needs to know the standard operating procedures of the legal system and the way in which answering the inquiries posed by the interrogators and advisors. Medical practitioner's witness. So, coming on as Indian Evidence Act 1872, section 45 of IEA says only registered medical practitioners who are enrolled in accordance with the section 15(2)(c) of the Indian Medical Council Act 1956 are qualified to testify as experts in various courts on any topic pertaining to medications or the treatment or the service hindered by them, etc. A medical witness is only an expert witness under section 45 of the Indian Evidence Act 1872, neither a prosecution nor a defense witness. A medical witness may or may not support the prosecution or the party calling him, but their testimony is to be presented within the bounds of science to help the court ascertaining the truth and giving the justice. Evidentiary value of medical witness. We will discuss with this case Tommaso Bruno and another versus State of Uttar Pradesh 2015 7 SCC 178. Expert testimony is typically given more weight by the courts, but they are not always bound by the experts' reports, particularly if they are flimsy and unsupportable. Though such a report is not definitive, the main goal of an expert opinion is to help the court reach a decision. The report will be examined by the court, which will then consider it in light of all the available evidence before determining whether or not to rely on it. So, coming to the oath, what do we mean by the oath that we take before giving our testimony in a court? A medical witness must take an oath or affirmation in accordance with the Oaths Act 1969, just like any other witness, prior to having his deposition recorded in court to giving a justice. What happens if two doctors provide contrary opinions? The court has the authority to rely more on one doctor's testimony than another when there are two doctors who have differing opinions. The doctor's testimony, if it supports the prosecution's versions of the event, may be the one the court chooses to consider. The above mentioned view has been held in the various case laws. For example, Pyara Singh versus State of Punjab, AIR 2001 SC 2939. Second, Makan Jeevan versus State of Gujarat, AIR 1971 SC 1797. State Government of NCT, National Territory of Delhi versus Sunil 2001 1 SCC 652. There are various case laws which two doctors have different opinion. Competency of a doctor in determining death. Only a doctor is qualified to speculate on the cause of death. Another we will explain with the help of this judgment. Sahibaro Mohan Berad versus State of Maharashtra 2011 CR LJ 2157 SC. When a doctor discovered a hematoma on the diseased neck and took into account both internal and external injuries, the doctor concluded that the death was caused by a rolling pin being pressed against the woman's neck. Additionally, there was evidence linking the accused husband to the deceased on the night of the incident, and since the accused offered no explanation for the wife's death, the accused faced the possibility of being found guilty of murder. It has been decided that the doctor's stated cause of death can only be disregarded if his assessment is fundamentally flawed. If not, only a doctor is qualified to speculate on the cause of death. Accuracy in determining death. We will go through these two judgments. First, Ramji Rai versus State of Bihar 2007 57 ACC 385 SC. Medical science is still far from perfect enough to allow a medical fraction to definitely pinpoint the precise moment of death. Second, Ram Swarup versus State of Uttar Pradesh 2040 ACC 432 SC. It is common knowledge that a doctor can never be completely sure of the exact moment or the extent of an injury when does it has happened to be the exact point of time. State of Uttar Pradesh versus Guru Charan 2010 SCC 721. Injuries that occur within 6 hours are considered fresh injuries. A difference of 2 hours could occur on either side. Therefore, the injuries that occur within 4 to 8 hours, but not later than 8 hours, are considered fresh injuries in the court of law. Disciplinary action taken in determining death. So, we will explain with the help of this judgment. Sahabuddin versus State of Assam 2013-80 ACC 1002 SC. It is expected of a doctor performing a postmortem on a deceased person to determine the cause of death. The Honorable Supreme Court has held that the doctor performing the postmortem had failed to fulfill his professional duty and had made an effort to assist the accused in the case, that he had neglected to note the cause of death and to preserve the viscera for chemical analysis in a lab. It was instructed that the Director General of Health Services take the doctor to task for his misconduct. Next concept, determination of age by the doctor or the various other parameters for the identification. The doctor's statement is merely his or her opinion, in addition to any oral testimony that may be available. The court must base its decisions on all the facts and circumstances that are revealed during an examination of the individual whose age is under dispute. So, the age determination is very much important as it varies from various parameters. Less than 12 have different law, less than 18 has different laws. We will explain with few judgments. First, Ramdev Chauhan versus State of Assam AIR 2001 SC 2231. An X-ray ossification test can be a more reliable method of estimating an individual's age than consulting a medical professional, but it is by no means a test that can pinpoint an individual's precise birth date. Toxicology, medical jurisprudence and the textbooks cannot be relied upon excessively when determining an accused person's age. It is unrealistic to expect uniformity in height and weight in this large country with its diverse latitudes, heights, environments, vegetation and nutrition. So, next scenario, eyewitness versus medical witness. So, in which favors the laws, whether it is eyewitness or the medical witness or the medical expert. Unless medical evidence is so strong as to rule out even the possibility that the testimony of eyewitness is accurate, eyewitness testimony should be given priority. We will explain through this judgment. Ajay Singh versus State of Bihar 2009 9 SCC 730. Here the eyewitnesses claimed that the victim had injuries from the pistol firing on his leg, but the postmortem report showed that the victim had an injury on a part slightly higher than his thigh and nothing on file to refute their testimony. It has been held that in the absence of ballistic expert's opinion and contradiction regarding the location of injury, it would not be sufficient to disregard the testimony of the eyewitness in a murder case. So, now the various tests to be done on the sexual assault victims. When addressing gender based violence, medical procedures should not be performed in a way that amount to cruel, inhuman or degrading treatment, and a patient health should always come first. So, always the first aid to be given as soon as possible. It is the state's duty to provide these services to victims of sexual assault. There should be no arbitrary or illegal interference with their privacy, and appropriate steps should be taken to ensure his or her safety. So, coming to the famous two-finger test, the Supreme Court forbade the use of the two-finger test in sexual assault crimes against women. In the light of International Covenant on Economic, Social and the Cultural Rights 1966 and the United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power 1985, medical procedures involving sexual assault survivor must be carried out in a way that upholds their right to consent. Another case, Lilu versus another versus State of Haryana. Physicians are prohibited from using the two-finger test, which is essentially a virginity test to assess whether or not sexual assault has occurred based on muscle laxity. The Supreme Court ruled out that the two-finger test is unconstitutional because it infringes upon the victim's right to privacy. So, the two-finger test is prohibited for determining whether the rape has occurred or not. Rape is a legal term, it should not be used as a medical. So, whether the sexual assault has occurred or not, two-finger test is prohibited to be done by the medical professionals. So, coming to the penetration and rupture of hymen will be explained with this judgment, Purachand versus State of Himachal Pradesh 2014-86 ACC 279 SC. Considering the provisions of section 114A of the Indian Evidence Act, the court should give the victim's version the utmost weight even if the medical evidence does not support the prosecution's case and does not show a rupture of hymen. This is because the definition of sexual assault or offense does not include that rupture or the penetration is mandatory. It also includes attempts to commit it. Even if there is a attempt to commit the offense or sexual assault, it should be considered punishable offense. So, the penetration or the rupture is not mandatory. Another case, Parminder versus State of Delhi 2014 to SCC 592. The Supreme Court held that since there was penetration that caused bleeding in the prosecutrix, the extent of penetration necessary to constitute the offense of rape as defined by section 375 of the IPC was immaterial, and the accused was rightly found guilty for the offense of rape under section 376(1) of the IPC. In the case of a girl aged between 14 and 16 years, the doctor had stated that during a medical examination there was no sign of injury on the prosecutor and the hymen was found intact. So, there are various scientific tests applied to investigate crimes, which are, before such scientific tests were formulated, truth was put to the test in medieval England by submerging a suspect in water or setting them ablaze, with the idea being that God would save them if they told the truth. An additional test required the suspect to carry a burning iron bar 9 paces. If he burned, the case was closed and he was executed right away. The accused was occasionally thrown into the river while tied with a sack of sand. If he floated, he was presumed guilty and hanged. If he sank, he was regarded as telling the truth. Both times the accused had to pass away. In England, laws prohibiting these lie detection techniques were passed in 1215. So, these are the various scientific tests to be done. Example, voice analysis test, RNA ribonucleic acid test, DNA to determine the DNA at the evidence, deoxyribonucleic acid, lie detector test, polygraph test, fingerprint test, brain mapping test, handwriting test, narcoanalysis test to find out or to give the justice in the administration of law. So, coming to the one by one, lie detector test. A lie detector test or a polygraph test is a device that records the apex beat of the heart as well as tracings of multiple distinct pulsation including venous and arterial pulse waves. An instrument called a lie detector or a lie detecting machine is used to find physiological signs of the tension that goes along with it. A lie detector machine is any gadget that captures the unconscious physical reactions connected to the conscious lying. Second, polygraph test in order to ascertain whether a statement is true or false. The polygraph device is supposed to record physiological changes in breathing, sweating, blood pressure and pulse rate with 100% accuracy. The instruments won't accurately record changes if it is malfunctioning. Without a comprehensive investigation, the polygraph test cannot be administered. Investigations must be exhausted by the investigating officer before requesting a polygraph test. The polygraph test can be used to verify the veracity of witness statements, coerce criminals into confessing to their crimes, substitute third degree methods used in police interrogations, help distinguish the guilty from the innocent, and assess the honesty and integrity of job candidates, employees and those who are subjected to the polygraph test. Third, brain mapping test. The accused is first questioned and interviewed in this technique, which is also known as brain wave fingerprinting, to see if he is withholding any information. The subject is then seated in front of a computer monitor with sensors attached to their head. After that, he is shown specific pictures or given specific sounds to hear. The sensor record P300 waves, which are only produced when a subject is in contact with the stimulus or picture or a sound, or track the electrical activity in the brain. If he knows such changes will come, otherwise will not. So, he will able to detect the truth. There are no questions posed to the subject. The brain of the accused triggers a murmur, that is memory and encoding related multiphased electroencephalographic response. This is a full form of MER, memory and encoding related multiphased electroencephalography response, when it detects significant information related to the offense. The term target stimuli refers to this stimuli. To put it briefly, the brain fingerprint test compares brain data with the information gleaned from the crime scene and help to find out the real truth or to find out the accused involved in that case. Another, narcoanalysis test, or we say the truth serum test, another name to be as narcoanalysis test. Narco plus analysis is a term for psychoanalysis that makes use of drugs to create a sleep like state. A truth drug such as sodium amytal is administered to the suspect during a narcoanalysis test in order to ascertain the facts surrounding the crime, to know what has actually happened, to know the truth surrounding the crime. The interview is titled amytal interview. It is thought that a person can be coerced into telling the truth if they are given a medication that inhibits their ability to reason while leaving their speech and memory intact. The subject speaks freely while under the influence of the drug and is allegedly unable to control his responses or exercise self-control. The subject speaks freely while under the influence of the drug and is allegedly unable to control his responses or exercise self-control, although he is unable to speak for himself. the subject is able to respond to brief and straightforward inquiries and let us know the real truth or whatever the scene he has seen and give the justice. So, the admissibility of these various scientific tests. The validity of a scientific test will determine whether or not its results are admissible. If and when the supporting materials are presented to the court, it will be necessary to further consider whether the brain mapping test is sufficiently developed such that the report will have sufficient probative value for the court to rely on it. Citing rules from the US Supreme Court in the cases of Fry versus United States 293 F 1013 DC CIR 1923 and Daubert versus Merrill Dow Pharmaceuticals Inc 113 SCT 2786 1993. The Supreme Court of India has determined that certain prerequisites must be met in order for scientific evidence to be admissible under section 45 of the Evidence Act. So, it is really difficult to find out the scientific tests are admissible or not, but mostly they help as a corroborative evidences in the court of law. The requirements for the scientific test admissibility we will discuss through judgments. Ranjit Singh Brahmajit Singh Sharma versus State of Maharashtra 2005 CRLJ 2533. Whether the principle or technique has been or can be reliably tested, whether it has been subject to peer review or publication, it is known for potential rate of error, whether there are recognized standards that control the procedure of implementation of the technique, whether it is generally accepted by the community, whether the technique has been introduced or conducted independently of the litigations. Another judgment, Salvi versus State of Karnataka 2010 7 SCC 263. It is imperative to note that an individual who is suspected of a crime cannot be compelled to partake in scientific examination such as narcoanalysis, polygraphy among others. This is due to the fact that such tests would constitute a kind of self-incrimination for the accused under Article 23 of the Constitution. While examination A to section 53, 53A and 54 of the CRPC, that is a Code of Criminal Procedure, allows for the administration of specific medical tests on the accused. It is important to note that the test of narcoanalysis, polygraphs and brain electrical activation profile are not encompassed under the aforementioned acceptable tests. If specific precautions such as those suggested by the National Human Rights Commission in relation to polygraph tests are followed, then the result of such tests may be considered as admissible evidence for a restricted purpose as outlined in the section 27 of the Indian Evidence Act. Admissibility of the DNA test, which is very important scientific test in administration of justice. Srimati Salvi versus State of Karnataka AIR 2010 SC 1974. The amended explanation to the section 53, 53A and 54 of CRPC Code of Criminal Procedure Code specifically lists the DNA profiling technique as one of the several forms of medical examination. A DNA profile differs from a sample of DNA that can be obtained from biological material found at the scene of crime. For the purpose of Article 23 of the Constitution, the use of material samples such as fingerprints for comparison and identification purpose does not constitute a testimonial act or compulsion. Therefore, in the context of India, there are no constitutional obstacles to the collection and preservation of DNA samples, which are essentially physical evidences found at the scene of crime. So, conclusion of this lecture 2 is the medical professionals are crucial to the administration of justice. They perform a very important role of qualified fact witnesses as an expert witness. They look into the facts, make them clear and advise and support the legal system. Physicians examine a patient's mental state and in cases where the matrimonial jurisdiction applies, a spouse, physical and mental health. Physicians also examine victims of trauma, domestic abuse, child abuse, sexual offences, identify and manage medical evidences, and assist the court in determining an accused person's guilt or innocence by giving their expert testimony and help in the administration of justice. These are the references, you can go through it for the further readings. So, first was the website of Cambridge, the British Journal of Psychiatry, one of the famous article. Second, references of one of the book, the chapter, you can go through that whole chapter for the further information. Third, scholarly article as a law.northwestern.edu, you can go through it. These are the references for the further information and readings. Thank you.